Simpson, a pathologist, testified in gruesome detail how the two victims had struggled in the minutes before they died. The week began well for Simpson's lawyers. They were given permission to question a witness about taped interviews conducted with Los Angeles detective Mark Furman. The interviews are said to contain racist comments by Furman and could help to support the defense theory that the detective planted evidence to implicate Simpson. The defense made other gains this week. A pathologist who reviewed the autopsies performed on the two victims testified that they both put up a fight before they were killed. But Simpson had no injuries on his body after the murders. The defense says this provides further proof that he cannot be the killer. On Monday, Dr. John Gerdes returned to the stand for his fourth day of intense questioning. He had reviewed for the defense the way the evidence was collected and the DNA testing procedures of the Los Angeles Police Department, and his results had been highly critical. Prosecution lawyer Woody Clark was determined to reduce the impact of Dr. Gerdes' statements. He cross-examined Gerdes about the results of the two types of DNA tests, known as RFLP and PCR, which were done on the bloodstains. The previous week, Gerdes had singled out the PCR test results as unreliable because of contamination.
Haven't you testified previously, Dr. Gerdes, that you have no problem with the RFLP technology?
I have.
And you've testified in this case that you have no problem with several of the RFLP matches in this case. Isn't that right?
That's right.
Isn't it in fact the case that if there's an RFLP match on a sample, in your opinion, that validates the PCR result on that sample?
It can.
Haven't you previously testified that it does?
I probably have in the past, yes.
Isn't it true that if there's an RFLP match on the same sample that a PCR result is obtained, that RFLP match confirms the PCR result on that sample?
Of course, you have to look at the samples. Even in RFLP, there are going to be circumstances where those kinds of results need to be looked at with suspicion in terms of whether it's a mixed sample and the same sorts of issues that we discussed earlier in general in terms of DNA technology and forensics. So you can't make a broad, blanket, general statement like that. You need to look at the circumstances for each item, even in an RFLP test.
Woody Clark then wanted to know if the defense had tried to carry out its own DNA testing on the bloodstains.
Dr. Gerdes, if one of those samples from the bloody blood drop trail, 47 through 52, if one of those was typed and it revealed a genetic marker, and I'm referring to the remaining evidence, that excluded Mr. Simpson, wouldn't that be important?
Yes.
That would be extremely important, wouldn't it?
Yes.
Have you suggested to the defense in this case that retesting should be done?
Sustained. Objection. Move to strike and ask for an instruction. Forward. On burdens of proof.
Wouldn't reanalysis of these samples support, if they produced exclusionary results, support your opinions in this case?
Objection. Overruled.
Not at this point.
Is it your view then that if further testing in this case revealed Mr. Simpson was excluded from item 52, that wouldn't support any of the opinions you've offered in this case about forensic DNA typing?
In my opinion, with the risk of contamination, there would be no possible PCR interpretation possible at this point because the samples have been handled in the way they have been.
When the jury left the courtroom for the morning recess, Johnny Cochran complained to Judge Ito about Woody Clark's suggestion that the defense could have done its own DNA testing to try and exonerate Simpson.
It's terribly unfair under the provisions of the state constitution, the U.S. Constitution, to try to shift the burden to Mr. Simpson. You don't have to prove, he does not have to prove anything. And I think that whole line of questioning is unfair. I'm making this objection primarily because I think it applies not only to this witness, but to others. And what I'm asking the court to do is to prohibit the prosecution from doing this, and also the appropriate time you will be instructing this jury, but to instruct them, the defense does not have to do any kind of testing in this particular case. And I think it's unfair. It's unfair inference. You mentioned Mr. Blake 100 times, and now we hear Blake and Taylor and what Gerdes could have done, and that's really unfair, Your Honor. And I wanted to at least address the court on this and ask you to give a curative instruction in that regard.
All right, that will be given and has been given as the court's normal instructions, that the burden is on the prosecution. However, there's also a long line of cases that during the course of argument, the prosecution can argue the failure to call logical witnesses.
But doesn't it fly in the face? My point is, just briefly, Your Honor, not to belabor it, doesn't it fly in the face of where you start off instructing the jury? We don't have to prove anything. Then they come along and they do exactly that, and then you instruct them that we don't have to prove anything. So I think
instructed them in the most graphic and simple way as I can, that Mr. Simpson can sit here and sleep through the whole trial if he cares to.
You did that. And so what I'm saying
is something that even you remember, Mr. Carter.
I remember that, and I remember that, Your Honor, and I just reminded you of that.
I'm sure the jury remembers that one, too.
Right.
That's why I use it.
The jury was brought back, and defense lawyer Barry Scheck asked Gerdes about the amount of DNA in a drop of blood collected from the rear gate at the crime scene.
What is your assessment in terms of the data that the Bundy blood drops were severely degraded with bacteria, and the rear gate sample 117 was not, and the rear gate sample had 150 nanograms of DNA, which was 5 times higher than any Bundy blood drop sample?
Same objection, same grounds.
Oral.
It doesn't seem to make sense to me that you should see about the same level of degradation, and in fact on 117, which is an older sample, it should have more degradation.
This was an important point for the defense, which claims that OJ Simpson's blood was planted on the rear gate, and that would explain the lack of degradation and the larger amount of DNA. But Woody Clark offered an alternative explanation. He wanted to know if the collection process could have caused the differing amounts of DNA in the various bloodstains.
Would you agree that the less time that a particular item spent in a plastic bag in a wet state, the more likely that sample would contain more DNA?
That's probably true.
As far as these number of factors that can account for differences in DNA levels, you would agree, would you not, that the time spent in those bags would be an important factor?
It would be one factor that's important, yes.
After a cross-examination in which he had conceded few points to the prosecution, Dr. Gerdes was finally dismissed. Although Gerdes' testimony had been at times dense and scientific, he had arguably been the defense's strongest witness of the trial so far. In another part of the country, the defense won an important victory on Monday. An appeals court in North Carolina ruled that a would-be screenwriter, Laura Hart McKinney, would be forced to testify in the Simpson trial. While researching a screenplay, McKinney had used Mark Fuhrman as an advisor. Fuhrman is the detective who said he found a bloody leather glove at Simpson's home the day after the murders, but the defense claims Fuhrman is a racist who planted the glove to frame Simpson. The defense want McKinney to testify about some tape-recorded interviews she did with Fuhrman in which he allegedly used the word nigger. But Fuhrman had testified earlier